Who is considered a victim under Idaho law? Brian Walshe has been indicted for the killing of his wife. Will we have a perp walk for the former president? The trial of the missing Orson boys is set to begin, and this is what happens when you harm a child. You get a 3,000-year sentence. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is CrimeTalk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment, and hit that little bell. And remember, you can always listen to us anytime on any of your favorite podcasting apps. Now, we got to pay the bills around here, so go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll literally be able to perform a background search while you wait. A report will be emailed to you, and it's going to have information as to whether somebody has a criminal history. Do they have judgments against them? Are they married? Are they divorced? All those little things you may want to find out about. Are they on one of those public registries, if you know what I mean? Is it going to be someone you want to bring over and introduce to mom and dad? Check them out, crimetalksearch.com. Okay, let's go ahead and open the record for the docket for March 31st of 2023. So as you may recall, on March 29th of this year, the court in the Lori Vallow matter called a hearing and determined that pursuant to the Idaho Rules of Evidence, Rule 615A, that any witness in the Lori Vallow matter is excluded from observing or listening to other witnesses' testimony during trial, excepting those witnesses who are victims as defined by Idaho law in Article 1, Section 22 of the Idaho Constitution. As you may recall, the defense for Lori Vallow was arguing that Kay and Larry Woodcock are not sufficiently related to JJ to be considered a victim under the Victims' Rights Act, and therefore they should not be entitled to basically victims' family seating in the courtroom. Now, Kay and Larry Woodcock issued a statement the other day saying that they thank everyone for all the support. After the hearing yesterday, they were completely blindsided and heartbroken at the arguments made, saying we are not JJ's grandparents and should not be considered victims in this case. The statement continues, we continue to be victimized by Lori every single day living without JJ, Tylee, and Charles, then again by possibly denying us the chance to be the face in the courtroom seeking justice for them. We made a promise over 3 years ago to Tylee and JJ to see justice prevail. We will fight until we have exhausted all options to keep that promise. They also state that they have hired Shannon Gray of the Gray Law LLC out of Oregon, and the statement says that as their attorneys fight on their behalf, we appreciate the prayers, and we will keep the promise to JJ and Tylee, Kay and Larry Woodcock. So there's the statement from the Woodcocks. We discussed this the other day in much greater detail. I'm sure Frank can put a link up to that video. But the gist is that Larry and Kay are not the family by definition in Idaho, and therefore they should not be able to be seated in the victim's seating area and have a right to attend the trial for all stages of the proceeding. Now, the Rule 615, exclusion of witnesses, states that at a party's request, the court may order witnesses excluded so that they cannot hear other witnesses' testimony, or the court may do so on its own. But this rule does not authorize excluding a party who is a natural person, an officer or employee of a party that is not a natural person after being designated as the party's representative by its attorney, basically designated witness in the particular case. And third, a person whose presence a party shows to be essential to presenting the party's claim or defense, or for a crime victim whose exclusion is prohibited under Article 1, Section 22 of the Idaho Constitution. Pretty straightforward, does it not? Well, Idaho statute, Section 19-5306, defines a victim as follows in paragraph 5. As used in this section, victim is an individual who suffers direct or threatened physical, financial, or emotional harm as the result of the commission of the crime or a juvenile offense. Not the best language there in the state of Idaho. The statute clearly tries to cover people who are victims and they survive a crime. But they didn't really go into the situation where, let's say family members are there because the victim passed away. So we'll have to see if Judge Boyce allows the Woodcocks to stay in for the entire trial by using that they are the victims of emotional harm as a result of the commission of the crime. Now, the statute is written somewhat poorly, but there is also Idaho Statute 9-5306, which is the Idaho Victims' Bill of Rights, and it says the rights of the victim during investigation, prosecution, and disposition of the crime. Each victim of a criminal or juvenile offense shall be treated with fairness, respect, dignity, and privacy throughout the criminal justice process. B, that they be permitted to be present at all criminal justice proceedings. The provision of this section shall apply equally to the immediate families of homicide victims or immediate families of victims of such youthful age or incapacity as precludes them from exercising these rights personally. And the court may designate a representative from the immediate family to exercise these rights on behalf of a deceased, incapacitated, or minor victim. Immediate family, curiously enough, is defined in the Idaho Code in the banking section. An immediate family means a spouse, child, sibling, parent, grandparent, or grandchild, and includes step-parents, stepchildren, step-siblings, and adoptive relationships. So the statute tries to cover people who are victims, and obviously somebody's there to describe a crime, but like I said, some genius forgot to designate this. Now, I think that Judge Boyce should allow the Woodcocks to stay for the entire trial, obviously by the emotional harm, as well as the fact that they could be listed as a designated family representative. We'll see what the judge does. Unfortunately, I think the defense may win on this particular argument. I hope that I'm wrong. There were some arguments made at the hearing the other day as it relates to somebody claiming to be grandparents or whether there was really of a biological nature, so to speak. The judge is going to have I think, a tough call on this one, but I think the court can come to the right result. Now, the plain language of the statute, somewhat clear, but it's also provides that a family representative can be there, and clearly the Woodcocks have been there from the beginning for JJ specifically, and certainly Ty Lee as well. And the bottom line is that this case probably wouldn't even have been brought but for the Woodcocks. So I hope the prosecution steps up a little bit more here and really fights for the Woodcocks in this particular case. Hopefully we'll see what's going to happen. Trial starts next week. I expect a court ruling sometime later today, after hours, that they won't post for the public to see, probably until Monday anyway. So hopefully a judge does the right thing. Next on the docket, Brian Walshe has been indicted by a Norfolk County jury for murder, as well as for misleading a police investigation, obstruction of justice, and for improper conveyance of a human body. That's right, his wife, Anna Walshe, went missing from a New Year's Eve party at about 1:30 a.m. on January 1st. Brian Walshe entered a plea of not guilty to the charge of murder in Quincy County, but the indictment that was returned moves the case to Norfolk Superior Court, and Mr. Walshe will be arraigned in the coming weeks. Anna's body, as you may recall, has not yet been discovered. Now, DNA evidence located throughout the investigation indicated that Brian Walshe killed Anna, dismembered, and discarded his wife's body parts in unknown locations. He is currently being held without bail. And like I said, Anna was reported missing on January 4th after her employer said she didn't show up for work, and not her husband. In initial interviews, Brian Walshe told police he last saw his wife when she left for Boston's Logan Airport on January 1st. The husband was arrested mere days later on January 8th on suspicion that he misled a police investigation. Originally, he was held on a $500,000 bond after investigators said they found blood and a broken knife in the family's basement. Police also alleged that they have surveillance video of Brian wearing a medical mask and surgical gloves purchasing some $450 in cleaning supplies with cash at Home Depot. Now, obviously, if he is convicted, which will give him the presumption of innocence, he faces a mandatory sentence to life without the possibility of parole. Next on the docket, will there be a perp walk for the former president, President Trump? So if you have not heard, former President Trump and now presidential contender for 2024 has reportedly been indicted. The indictment has not been unsealed, but that is supposed to take place next week. Now, this has to do with the alleged payments made to former porn star Stormy Daniels, who was represented by Michael Avenatti, who is currently serving time in federal prison. The other key witness is Trump's former personal attorney, Michael Cohen, and he too has served time and is a felon for his tax issues. Then we also have Alan Weisselberg, the former chief financial officer for the Trump Organization, currently incarcerated at Rikers Island, and he recently switched lawyers amid ongoing investigations into the former president's business. As you may recall, the attorneys were being paid for by the Trump Organization. Now, the reason for the switch is in dispute. Apparently, some people familiar with their relationship said that the Trump Organization would no longer foot the bill for Weisselberg's attorney, who clashed with company officials over the legal advice he provided to the ex-CFO concerning his level of cooperation with prosecutors investigating the former president. But a Trump attorney said it was simply a personal decision that Weisselberg made with his family and others, and that the company had no role in the change. I've been in this kind of situation. It's usually because somebody that's paying the bill doesn't like the legal advice that you are giving to their client. Remember, the attorney's duty, regardless of who is paying the bill, is to the client. So the question here, has Mr. Weisselberger flipped? There are reportedly many allegations in the indictment alleging fraud related to the business. Could that be part of it? So is this a case of no one is above the law, or the elected state district attorney, not the attorney general, who ran on, quote, getting Trump? Is it a witch hunt? To be determined. President Trump's indictment marks a historic first. As of Friday afternoon, when we're doing this video, the precise nature and obviously the number of charges remain unknown. But the fact that a felony indictment against a former president brings down a barrier that has stood since nearly the country's inception. For nearly 250 years, no president has ever faced criminal liability for their actions. He'll be the first president arrested since Ulysses S. Grant was pulled over for speeding in his horse and buggy at the corner of 13th and M Street in Washington, D.C. in 1872. He was let go with a fine. So, as I said, during the 2021 campaign, Bragg positioned himself as a liberal district attorney, and he has argued that by charging fewer crimes and reducing jail population, the government can promote alternatives to incarceration, and that safety in the cities will follow. How's that working out in New York? Anyway, Mr. Bragg campaigned to lower gun violence, protect survivors of domestic abuse, and not prosecute some low-level misdemeanors, such as marijuana use and jumping turnstiles. However, he did face some backlash when he tried to make it a misdemeanor to rob a business with a gun. Yeah, he withdrew that proposal. Bragg has also said that he wants to change the culture of the district attorney's office, and as a former civil rights attorney who represented Eric Garner's mother as she sought accountability for her son's death at the hands of police in 2014, Mr. Bragg said he believes law enforcement officials must be held to higher standards. On taking office, he created a police accountability unit to investigate officers who engage in criminal conduct in their policing, and a post-conviction justice unit to reinvestigate closed cases in which there are credible claims of actual innocence or an unjust conviction. So whether you hate the former president or think he is the greatest, well, we will bring you the facts with the law, and frankly, let the chips lie where they may. If it is a weak case, we'll tell you. If we think the former president has a problem, we'll tell you as well. Only time will tell if it is a political witch hunt or a righteous prosecution. I know we don't have the facts, we don't have the indictment, but let me know what you think in the comments. It could be the trial of the century. A former president and a porn star. You know it's got to be good. Next on the docket, do you remember the missing West boys? I know it's been a while, and this case kind of dropped off the radar, but the trial of the adoptive parents of Orrin and Orson West should begin early next week. A motion hearing in the case of Trezell and Jacqueline West is set for next week, and jury selection is to begin the week of March 20th. It's going to take several weeks to get the jury, and opening statements are expected to begin in early April. Prosecutors allege Orrin 4 and Orson 3 were killed about 3 months before the Wests reported them missing back in December of 2020. This was all from their home in California City, and the bodies of the young boys have never been found. The Wests are charged with the second-degree murder, involuntary manslaughter, and child cruelty, among a sundry of other offenses. Trezell West told authorities the boys were playing outside while he was gathering some firewood. He said he briefly went inside and the boys vanished when he came back outside. Jacqueline West backed up her husband's claims. Dozens of searches have been conducted and diggings performed throughout California City and Bakersfield, but nothing has come of that. No bodies have been located. Interesting case, like I said, kind of fallen off the radar because the judge had ordered some gag orders in this particular case, and it just hasn't got a whole lot of press. Kind of disappointing, probably a little bit on me too. There just wasn't that much going on that we were able to find out about. Anyway, harm a child, get sentenced. How long? Yeah, 3,000 years. Now, we hear a lot about life without the possibility of parole. Homicide cases is usually when that happens. Oftentimes, people get large sentences that result in, well, life without parole. They'll never get out. Let me give you an example. Please meet Matthew Perry. Well, he was found guilty in November, and he was convicted of 13,143 felonies after a trial. The 44-year-old will not be eligible for parole until the year 3523. Now, the district attorney in this case took a unique stance when it came to charging the defendant. He had a charge for one count for every day the victim was abused, starting from the age of 5. Now, during the trial, the district attorney said the victim testified that she was sexually assaulted every day and that it was as routine as brushing her teeth. And a unanimous jury found Mr. Perry guilty of 2,190 felony charges of rape of a child under 13, 2,190 felony charges of deviant sexual intercourse with a child, 2,191 felony charges of aggravated indecent assault, 2,190 felony charges of incest of a minor, and 2,191 felony charges of indecent assault. He was charged in this case in October of 2020 while awaiting trial on charges of doing the same thing to another child. For the second case, he was sentenced to 40 to 80 years last May. For the 2020 case, he was convicted in November of last year. I think that just about ought to put him away for the rest of his life. If you were doing that to a child every day, you probably deserve that and then some. I don't think he's going to have a fun time in prison, just saying. Anyway, next on the docket, our dumb criminal of the day. A man accused of stealing a car apparently could not resist another theft when he literally bonded out of jail. So get this. A bail bond agent in Charlotte, North Carolina, left her vehicle and claims that it was stolen after she went inside the county jail to post bail for a client. And she is accusing a man who had just posted bail for swiping her vehicle. The bail bondsman states that he has to be the boldest and dumbest criminal in the city. Now, the alleged suspect is Anthony Deshaun Goddard. Well, he posted a $3,000 bail after being arrested, and he was charged with possession of stolen goods, resisting an officer, reckless driving, speeding, and operating a vehicle without an operator's license. Video showed Goddard breaking into the bail bondsman's SUV and driving away. She has spoken to other bail bondsmen in the area and believes that bail will be next to impossible to secure if the alleged thief is ever caught. She has reiterated her message to the person who swiped her vehicle. "I would say you are stupid," she said. "You're the stupidest criminal, and I can't wait until you get caught, because no one is going to bond you out," the bail bondsman said. Well, the vehicle is still missing. No arrests have been made. But I agree with the bail bondsman. Yes, Mr. Goddard, you are dumb. And talking about the biting the hand of the person that feeds you, who's going to get you out? You're not going to have another $3,000. You're going to need that bail bondsman. And you just burned that bridge. Dumb, 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 dumb. And doing it while you were literally at the jail. Are you such an idiot that you don't think that there was actually video surveillance at the jail? My God. Yes, the bondsman is correct, Mr. Goddard. You are the stupidest person in North Carolina. If definitely in the top 10 in the country. Just saying. All right, thanks for watching. Have a wonderful day, and we'll see you next time on Crime Talk.